I don't know why it's tripping like that, bro. Straight up trip. Chapter 7. A right considered as a faculty of the obligation thereto corresponding. Besides the general idea of right, such has now been explained, considering it as a primitive rule of human actions, this term is taken in several particular significations, which we must here point out. But previous to everything else, we should not forget the primitive and general notion we have given of right, for it is from this notion, as from its principle, that the subject of this and the following chapters is deduced. If our reasonings are exact in themselves, and we have a necessary connection with the principles, this will furnish us with a new argument in its favor. But if unexpectedly it should turn out otherwise, we shall have at least the advantage of detecting the error in its very source, and of being better able to correct it. Such is the effect of a just method. We are convinced that a general idea is exact when the particular ideas are reducible to it as different branches to their trunk. In the first place, right is frequently taken for a personal quality, for a power of acting or faculty. 'Tis thus we say that every man has a right to attend to his own preservation, that a parent has a right to bring up his children, that a sovereign has a right to levy troops for the defense of the state. In this sense, we must define right, a power that man hath to make use of his liberty and natural strength in a particular manner, either in regard to himself or in respect to other men, as far as an exercise of his strength and liberty is approved by reason. Thus, when we say that a father has a right to bring up his children, all that is meant hereby is that reason allows a father to make use of his liberty and natural force in a manner suitable to the preservation of his children, and proper to form their minds and hearts. In like manner, as reason gives its approbation to the sovereign, and whatever is necessary for the preservation and welfare of the state, and particularly authorizes him to raise troops and bring armies into the field in order to oppose an enemy, and in consequence hereof we say he has a right to do it. But on the contrary, we affirm that a prince has no right without a particular necessity to drag the peasant from his plow, or to force a poor tradesman from their families, that a father has no right to expose his children or to put them to death, and because these things, far from being approved, are expressly condemned by reason. We must not therefore confound a simple power with right. A simple power is a physical quality. It is a power of acting in the full extent of our natural strength and liberty, but the idea of right is more confined. This includes a relation of agreeableness to a rule which modifies the physical power and directs its operations in a manner proper to conduct man in a certain end. 'Tis for this reason we say that right is a moral quality. 'Tis true, there are some that rank power as well as right among the number of moral qualities, but there is nothing in this essential opposite to our distinction. Those who rank these two ideas among moral entities understand by power pretty near the same thing as we understand by right, and custom seems to authorize this confusion. For we equally use, for instance, paternal power and paternal right. But this, as it will, we are not to dispute about words. This main point is to distinguish here between physical and moral. And it seems that the word right, as Puffendorf himself insinuates, is fitter itself than power, to express the moral idea. In short, the use of our faculties becomes a right only as far as it approved by reason, and is found agreeable to the primitive rule of human actions. And whatever a man can reason reasonably performed becomes in regard to him a right, because reason is the only means that can conduct him in a short and sure manner to the end he proposes. There is nothing therefore arbitrary in these ideas. They are borrowed from the very nature of things, and if we compare them to the foregoing principles, we shall find that they form thence a necessary consequence. If anyone should afterwards inquire on what foundation is it that reason approves a particular exercise of our strength and liberty in preference to another, the answer is obvious. The difference of those judgments arises from the very nature of things and their effects. Every exercise of our faculties that tends of itself to the perfection and happiness of man meets with the approbation of reason, which condemns whatever leads to opposite ends. Obligation answers to right, taken in the manner above explained, and considered in its effects with regard to another person. What we have already said in the preceding chapters concerning obligation is sufficient to convey a general notion of the nature of this moral quality. But in order to form a just idea of which comes under our present examination, we are to observe that when reason allows a man to make a particular use of his strength and liberty, or which is the same thing when it acknowledges he has a particular right, 'tis requisite by a very natural consequence that in order to ensure the right to man, she should acknowledge at the same time that other people ought not to employ their strength and liberty in resisting him in this point, but on the contrary, that they should respect his right and assist him in the exercise of it, rather than do him any prejudice. From thence the idea of obligation naturally arises, which is nothing more than the restriction of natural liberty produced by reason, inasmuch as reason does not permit an opposition to be made to those who use their right, but on the contrary, it obliges everybody to favor and abet such as do nothing but what she authorizes, rather than oppose or traverse them in the execution of their lawful designs. Right, therefore, and obligation are as the logicians, Logicians, logia, Jesus, those logicians express it. Two correlative terms. One of these ideas necessarily supposes the other, and we cannot conceive a right without corresponding obligation. How, for example, could we attribute to a father the right of forming his children to wisdom and virtue by a perfect education without acknowledging at the same time that children ought to submit to paternal direction, and that they are not only obliged to make any resistance to this respect, but moreover they ought to concur by their docility and obedience to the execution of their parents' views? Where otherwise, reason would be no longer the rule of human action, it would contradict itself, and all the rights it grants to man would become useless and of no effect, which is taking from one with one hand and gives him with another. Such is the nature of right taken from the faculty and of the obligation thereto corresponding. It may be generally affirmed that man is susceptible of these two qualities as soon as he begins to enjoy life and sense, yet we must make some difference here between right and obligation in respect to the time in which these qualities begin to unfold themselves in man. The obligations a person contracts as man do not actually display their virtue till he is arrived to the age of reason and discretion. For in order to discharge an obligation, we must first acquaint with it. We must know what we do and be able to square our actions by a certain rule. But as for those rights that are capable of procuring an advantage of a person without his knowing anything of the matter, They date their origin and are in full force from the very first moment of his existence, and lay the rest of mankind under an obligation of respecting them. For example, the right which requires not only the right which requires that nobody should injure or offend us belongs as well to children and even to infants that are still in their mother's wombs as to adult persons. This is the foundation of that equitable rule of Roman law which declares that infants who are as yet born in their mother's wombs are considered as already brought into the world. Whenever the question relates to anything that may turn to their advantage, but we cannot with any exactness affirm that an infant, whether already come or coming into the world, is actually subject to any obligation with respect to other men. This state does not properly commence with respect to men, still, till he has attained the age of knowledge and discretion. I'm going to read that again. This state does not properly commence with respect to man till he has attained the age of knowledge and discretion. Various are the distinctions of rights and obligations, but it will be sufficient for us to point out those only that are most worthy of notice. In the first place, rights are natural or acquired. The former are such as appertain originally and essentially to man, such as are inherent in his nature, and which he enjoys as man independent of any particular act on his side. Acquired rights, on the contrary, are those which he does not naturally enjoy, but are owing to his own procurement. Thus, the right of providing for our preservation is a right natural to man, but sovereignty, or the right of commanding a society of men, is a right acquired. Secondly, rights are perfect or imperfect. Perfect rights are those which may be asserted in rigor or even by employing force to obtain the execution or to secure the exercise thereof in opposition to all those who should attempt to resist or disturb us. Thus, reason would empower us to use force against anyone that would make an unjust attack upon our lives, our goods, or our liberty. But when reason does not allow us to use forcible methods in order to secure the enjoyment of the rights she grants us, then these rights are called imperfect. Thus, notwithstanding reason authorizes those of themselves are destitute of means of living to apply for succor to other men, yet they cannot, in case of refusal, insist upon it by force, or procure it by open violence. 'Tis obvious, without our having any occasion to mention it here, the obligation answers exactly to right, and is more or less strong, perfect or imperfect, according as right itself is perfect or imperfect. Thirdly, another distinction worthy of attention is that there are rights which may be lawfully renounced, and others that cannot. A creditor, for example, may forgive a sum due to him if he pleases, either in the whole or part, but a father cannot renounce the right he has over his children, nor leave them in an entire independence. The reason of this difference is, there are rights which of themselves have a natural connection with our duties, and are given to man only as means to perform them. To renounce this sort of right would be, therefore, renouncing our duty, which is never allowed. But with respect to rights that no way concern our duties, the renunciation of them is illicit, and only a matter of prudence. Is licit, not illicit. The renunciation of them is licit and only a matter of prudence. Let us illustrate this with another example. Man cannot absolutely and without any manner of reserve renounce his liberty, for this would be manifestly throwing himself into a necessity of doing wrong, where he so commanded by the person to whom he has made his subjugation. But 'tis lawful for us to renounce a part of our liberty, if we find ourselves better enabled thereby to discharge our duties and to acquire some certain and reasonable advantage. 'Tis with these modifications we must understand the common maxim that 'tis allowable for everyone to renounce his right. Fourthly, right and time, considered in respect to its different objects, may be reduced to four principal species. 1. The right we have over our own persons and actions, which is called liberty. 2. The right we have over things or goods that belong to us, which is called property. 3. The right we have over the persons and actions of other men, which is distinguished by the name of empire or authority. 4. And in time, the right one may have over other men's things, of which there are several sorts. It suffices at present to have given a general notion of these different species of right. Their nature, their effects will be explained when we come to a particular inquiry into these matters. Such are the ideas we ought to have of right considered as a faculty, but there is likewise another particular signification of this word by which it is taken for law, as when we say the natural right is the foundation of morality and politics, that it forbids us to break our word, that it commands the reparation of damage. In all these cases, right is taken for law, and as this kind of right agrees in a particular manner with man, 'tis therefore a matter of importance to clear and explain it well, which we shall endeavor to perform in the following chapters.